So, having introduced the idea of international human rights law, we should probably talk about how international human rights law is actually enforced, or if it is actually enforced, or to what extent it is actually enforced. One mechanism that potentially is available to enforce and respond to gross abuses of human rights, something that comes out of the responsibility to protect doctrine, is the idea that human rights abuses might justify a military intervention. And indeed, we do see situations in which states intervene militarily to stop gross human rights abuses. NATO pressure in Kosovo and in Bosnia in the 1990s might fit this definition. The international efforts to stop ISIS's genocide against the Yazidis might fit this definition. We could probably find a handful of others, but I would highlight that international intervention to stop human rights abuses is erratic at the best. There's intervention in Bosnia, but there's not intervention in Rwanda. There's intervention in Kosovo, but there's not intervention in Myanmar or Burma. Any number of equivalently awful atrocities against human beings oftentimes get overlooked for every intervention that there is. And the interventions that do take place may be politicized. They may coincide with the security interests of states in ways that maybe raise questions about the actual motivations behind the intervention. Interventions are almost always strong states against weak states. In theory, UN Security Council approval could resolve some of that, and the UN Security Council could provide a seal of permissibility that has not always been secured in advance of military intervention to stop gross human rights abuses. And indeed, under international law, there's a scenario in which the crime of genocide actually trumps the principle of sovereignty, that under the Genocide Convention, all states are obligated by having signed the Genocide Convention to take action to stop genocide when they perceive that the crime of genocide is occurring. Genocide being an attempt by a government to destroy a community of people in whole or in part. And again, that may supersede a need for UN Security Council sign off, but it ends up getting murky, and again, it ends up being erratic. So a different strategy, rather than states taking military action against other states, is the prosecution of individuals. And so increasingly, it has been the case that individuals who are responsible for committing atrocities, for gross human rights abuses, for the crime of genocide, may be prosecuted. And they may be prosecuted by international courts, international tribunals. They may be prosecuted by domestic courts. So Saddam Hussein, after his ouster, was tried by a domestic court system that was set up within Iraq for his prosecution for crimes against the Iraqi people. Sometimes folks who committed war crimes or crimes against humanity may be tried in domestic courts, but domestic courts in other countries. And so Augusto Pinochet, who had ruled over Chile for a number of years, ends up being tried in Spanish courts for crimes that he had committed while dictator of Chile. So there's a variety of judicial mechanisms to try to hold dictators and those who committed atrocities to account. And indeed, there seems to be some evidence that this is creating maybe a norm against atrocities, or at least maybe the reasonable expectation / fear that the committing of atrocities will yield consequences at some point in the future. Folks have shown that in the wake of dictators being prosecuted for abuses of power, dictators in neighboring countries tend to be less heavy-handed, which is kind of an interesting finding. It suggests that maybe those committing atrocities are sensitive to these kind of consequences. There's also been the development of a more robust international court system to deal with gross human rights abuses. After World War II, there were a series of tribunals that were set up to deal with the crimes committed by the Japanese and the crimes committed by the German Nazis as part of their wars of conquest and occupation. There was a sense, however, that that process was very ad hoc. It was created by victors. It was imposed on the vanquished. The crimes that were being prosecuted were not necessarily well established in international law, and it was also uncertain who was going to be targeted. Do you go after the folks at the bottom who actually committed the crimes, or do you go after the top? With the tribunals in after World War II, the sense was, well, largely the leadership should be held to account. Not that following orders is a defense that a soldier can rely upon, but that just for logistical and administrative reasons, there's not the ability to try tens of millions of people who participated in various aspects of these atrocities. The leadership is where the focus needs to be. And yet after that tribunal system sort of played itself out by the 1970s, the international community kind of walked away from it and said, well, we're done with that. And the tribunal system sort of lay dormant until the early 1990s, when a renewed set of atrocities, both in the former Yugoslavia and then in Rwanda, led the international community to set up a new set of international tribunals to try to respond kind of after the fact to crimes that had been committed, to atrocities that had been perpetrated. There was a sense that that process was replicating many of the same kinds of, I don't want to say limitations, but criticisms of the World War II tribunal. And so after the establishment of the Yugoslav and Rwandan tribunals, the international community began negotiating and figuring out how to establish a permanent tribunal with the creation of the International Criminal Court, which would be a permanent court that would be in a position to prosecute war crimes, crimes against humanity, the crime of aggression, and genocide, and would have the authority to do those things in a more regular and systematic way than this sort of ad hoc system that had kind of prevailed. I should detour very briefly before returning to a larger conversation about the International Criminal Court, and know that there are other human rights focused courts that exist within the international system. These courts are a little bit unique compared to like the International Court of Justice, which deals just with disputes between states. International human rights courts are able to hear cases or complaints brought directly by individuals who would say, we believe our human rights have been violated by our country. And those courts may hear a complaint that's brought to them if they determine that they have jurisdiction. And that jurisdiction is really, that the condition around that is really important for understanding the intersection of international human rights related courts, including the International Criminal Court, and domestic courts. And so an international human rights court would only be able to say that they have jurisdiction in response to a claim or a case that's being brought under the principle of complementarity, which means international courts do not exist to replace or supplant domestic courts. That international courts are there as a backstop when either domestic courts have ceased to function, there's been a war, the state has collapsed, there are no domestic courts you can appeal to. A situation in which the domestic courts have asked for assistance and have deferred to the international courts, or a situation in which the domestic court system is so corrupt that part of the complaint is there is no possible way for me to get redress for this thing that's been done through the domestic court process because it is captured by the political process that's responsible for this violation of my human rights. So it's only when one of those three things is in play that an international human rights court can step in and say, well, we have jurisdiction. The one exception to that might be the European Human Rights Court, where part of the job of the court is to kind of help arbitrate within the European Union. So I'll kind of set that one aside. But courts like the Inter-American Human Rights Court and the International Criminal Court operate under this principle of complementarity. And I want to use that as my jumping off point for a little bit of a backstory about the United States and the International Criminal Court, because the United States and the International Criminal Court have had this long, uneasy relationship. Initially, when the Rome Statute was being negotiated to establish the International Criminal Court in the 1990s, President Bill Clinton was actively supportive of the Rome Statute. He signed onto the Rome Statute, but did not submit it to Congress for ratification to the Senate. And it noted quite likely that it wasn't going to happen within the U.S. domestic political structures, that he wasn't going to be able to get 67 votes for it. But he wanted to give his seal of approval, his moral support to the idea of the International Criminal Court. When the Bush administration came to power in 2001, one of the first things that the Bush administration did is to unsign the Rome Statute, to not give the moral weight of the United States to the International Criminal Court. And in fact, the Bush administration lobbied countries against ratifying the Rome Statute to try to prevent it from coming into effect. When it did finally when it became clear it was going to come into effect, the Bush administration initiated a crisis in the UN system and essentially locked down the entire UN peacekeeping system to force a conversation about how to further insulate the United States from the International Criminal Court. The solution that came out of that was that the United States got a window of time to negotiate additional bilateral agreements. And so if we're thinking about the potential jurisdiction of the International Criminal Court, it really only has jurisdiction over countries that have signed onto and ratified it, or who have been given jurisdiction, or where the jurisdiction of the court has been granted by the UN Security Council. And so the United States ends up being triply protected from the International Criminal Court. First, it's protected by the fact that the U.S. has not signed or ratified the International Criminal Court and holds a veto at the Security Council, so that the UN Security Council could not extend jurisdiction of the International Criminal Court to the United States. Second, the United States is protected under the principle of complementarity, that the International Criminal Court does not just pursue cases against people or countries or situations just because it wants to. It operates when there is a breakdown in the normal justice system. And so the United States has a robust Uniform Code of Military Justice that is in compliance with the Geneva Conventions. And if soldiers engage in atrocities, target civilians, that sort of thing, they are consistently tried and frequently found guilty of crimes. Sometimes that percolates up to the officer corps. It almost never percolates up to the political class, which perhaps explains the concern on the part of some politicians about International Criminal Court jurisdiction, that principle of complementarity might not actually apply in their situation, but it certainly would not give the court jurisdiction to go after some random private who's stuck in a difficult situation and makes a mistake. So principle of complementarity insulates the United States. But the Bush administration secured a third insulation for the United States, which is to negotiate a series of bilateral agreements with other countries that they will not comply with International Criminal Court arrest warrants issued against Americans. And so we don't know how many countries signed these agreements with the United States. They are oftentimes kept secret. You could probably infer a number of them based on places where there are large bases, U.S. bases, places that participated in the United States' Black Site program during the global war on terror to interrogate captured Al-Qaeda members in a extra-legal, I'm using interrogate, torture, in an extra-legal environment. Those countries are likely to have signed these kind of bilateral agreements with the United States. But the idea is to create a network in which the United States is able to operate without risk of military personnel, intelligence officers, or politicians being potentially targetable by the International Criminal Court. So all of this is to say that the United States has been very cognizant of the risk of the International Criminal Court, and as much as it has supported efforts to try former dictators and to try crimes against humanity in a broad general sense, in the sense of creating an institution that might in some way constrain the United States or potentially target the worst of the worst case of abuses, the United States has been very hesitant to extend that level of cooperation to international organizations.